A series of new laws have rolled in. We highlight a few. And one high-profile law is met with some resistance. We explain in this week's Capitol Report. Hello, everybody, and welcome to this week's Capitol Report. I'm Julie Barkey. August 1st ushered in a series of new laws. Arguably, the one that garnered the most attention is the same-sex marriage legislation. Now, we spoke to the author of that legislation last week, Senator Scott Dibble. So this week, we're going to touch on several other bills that just took effect. Underage drinkers will be able to help someone who needs it without fear of a minor in consumption ticket. The law states if you've been drinking and you're under the age of 21 and you call 911 to help somebody who needs it, you are immune from any citations. Senator Barb Goodwin carried the legislation that provides immunity to underage drinkers who do call 911. She's here to talk a little bit about that legislation and a couple of other pieces as well. Thanks for joining us.
Thank you, Julie.
So, Senator, let's begin with this piece. Now, to avoid a ticket, the law states a person must have immediate health or safety concerns, and anyone calling to get help for another must remain on the scene and provide contact information to police. So what do you think constitutes immediate health or safety concerns?
It could be anything from somebody choking, over drinking and choking, and that has happened several times where somebody, chokes on their own vomit, and so if they call on that, it could be that they're suicidal. It could be that they are passed out in a semi-coma, alcoholic semi-coma, or coma, and those are all immediate things. It also could be that their safety could also include that perhaps they were threatening to walk out into the river or threatening to drive their car or something like that when it's obvious that they're very inebriated.
Was there kind of a culture of fear, and is there a culture of fear of calling 911 because of fear of a ticket?
Absolutely. What happens, and especially in colleges, is that students worry about the possibility of losing their ability to get a license, maybe for some practice, maybe for teaching or accountancy or something like that. If they get a ticket for underage drinking, some different kinds of licensure will, some different kinds of jobs will reject them as well, if the licensure doesn't.
Let's talk a little bit about the universities. While underage students will be protected by this law, the University of Minnesota can still sanction students under its student conduct code. Do you think this might deter some students from calling 911?
I think that it could. I'd hope the university would retract that and change that, because I think it's very important. First of all, this law came from University of Minnesota students who realized there was a big problem out there with people being left at parties alone sometimes when they were very ill, or left in a dorm room or whatever because people were afraid to call. So if the university is still going to sanction these students if they're calling on an emergency, or if they're the person in that emergency, then it's going to create the same kind of issues that we already have. They can't arrest them for it, or they can't give them a ticket for underage drinking, but they can sanction them scholastically, and that will also deter people from calling.
And prior to this law, it was really up to a police officer or sheriff or whomever the law enforcement was to use their own judgment on whether or not to give a ticket. Why did you feel the need to carry this and to actually provide overall immunity?
Because basically it's in the statute that underage drinkers, there's sanctions for underage drinking, and there wasn't any exclusion like this for people calling. So some officers would not charge them, but a lot of others would, and in order to make it because they felt like they were following the law the way that it was. There was no exclusion in law. So to put this exclusion in law and to allow somebody to call and get help for the other student is definitely going to be a life-saving thing, and it'll be consistent now across the state.
Now, 16 other states do have similar statutes. Were there any areas of concern that sprung up from those other states that maybe were incorporated into our law? In other words, how tight do you think Minnesota's law is?
Because of some of the changes, amendments that were made in committee, it tightened it up a lot more than what some other states have done, because it also allowed somebody to go out and flag somebody down or whatever, and it's restricted now to appease mostly the Sheriff's Association, that it would be restricted to them giving a call and being there, staying in the place until the help came. Otherwise, they could go to a neighbor or go somewhere and try to get help close by. So in that way, ours is a little more restrictive than some of the other states.
Okay, Senator, you had a couple of other pieces of legislation that took effect August 1st as well. One of those allows the police or law enforcement to take and keep the money of somebody who is trying to solicit a prostitute. What was the law prior to that?
Prior to that, they could take a vehicle or other equipment that was used in the offense, but they couldn't take the money from the person that was soliciting for prostitutes. And now what they can do under this law is they can take the money off of them. The reason, this is for a couple of reasons this is important. One is that sexually exploited youth are involved a lot of times, and people that do that to young people should lose the money, at least that they were going to spend in that case. The big reason for this, though, is, in my opinion, was to make sure that we put some money into the Safe Harbor program for sexually exploited, sexually trafficked kids or whatever, so that they have a place to go if they want to get away or trying to get away from somebody that's trying to exploit them for sex.
Okay, and finally, you also expanded a law that protects the finances of vulnerable adults. What are some of the key changes? Well,
the key change in that one is that it now, the case can be held against somebody in the county that the victim resides in. It used to be maybe the county that it happened in, but a vulnerable adult can be moved into a nursing home in a different county, or can be moved into assisted living or apartment, whatever. And so it should be able to, the case should be able to follow the adult where they are, the victim where they are. And that's what they can do now. In addition to that, they can aggregate 6 months worth of, for example, if you were an elderly person and I was stealing money from you on your credit card, they didn't necessarily have the ability to aggregate all of the months you did that to me before I could find out. So to charge it with whatever crime that would be based on the size of the financial theft. So now they can. Now they can, consolidate those months that.
Okay. Okay, Senator Barb Goodwin, you obviously had a very busy 2013 legislative session, and we look forward to talking with you again in 2014. Thanks for joining us.
Thanks, Julie, and I'm really glad you talked about the underage drinking bill, because if people don't know about that, then it doesn't really do any good to pass it. So with school coming up, as you mentioned previously, it is important for students to know that they want to save a life.
Well, again, thanks for coming in. We appreciate it.
Thank you.
In an effort to improve bike safety, the legislature passed a law that makes it illegal to drive through, stop, or park in a bike lane. There are a few exceptions, and the Minnesota Department of Transportation details all of the rules and regulations that apply for bikers and drivers. Family reunification was traditionally structured to help immigrants be reunited with their families who live in different countries. But a new law just took effect that pertains to domestic situations, and we have the person who carried that legislation in the Senate joining us now, Senator Kathy Sharon. Thanks for joining us. We appreciate it.
I appreciate the chance to talk about this bill.
Yeah, Senator, let's begin with what exactly does your Family Reunification Act do?
Well, this is a bill that addresses the issue that a lot of young people who are put in care of the state because parents have neglected them or have engaged in behaviors that have endangered the life of a child, and those parental rights are removed. The children are placed in foster care, and sometimes they get adopted out of foster care, but sometimes they don't. So this piece of legislation specifically speaks to those children who have been in the system for a while, been protected, whose family might have done a number of things to improve their circumstances, improve their parenting skills, resolve the issues that might have contributed to the neglect that they engaged in that caused them to lose their parental rights. And so this is a process that allows those families, after they've lost their parental rights, to consider the possibility of family reunification under very specific circumstances.
And let's talk about some of those circumstances, and more importantly, the exceptions where perhaps family reunification cannot be an option.
Yes, there are circumstances under which this would never apply, and that is in the case where there has been sexual abuse, or if there was the death of a minor as a result of the parental activity, or very egregious kind of behavior towards children. This is really directed towards those families that may have had some problems with chemical dependency that might have been resolved, or were very young and had not learned good boundary setting or parenting skills and had used physical discipline or physical aggression and gone too far. These children are children who have been in the system for a while. They have to have been in foster care at least 36 months. They have to be at 15 years of age, and they have to be able to go back into a family that is clearly demonstrating that they've resolved and taken care of the issues for which the reason that they lost custody of their children occurred in the first place.
Most states do have some form of a reasonable effort law that's aimed at keeping families together. How strong do you think Minnesota's law is, this family reunification law? Do you think it's tight?
I think, is it tight? Could you help me understand what you mean by that?
Meaning, do you believe that the systems in place are going to protect children from going back into households they shouldn't be in?
I think the limitations on this are quite strong. This has been brought forward by the County Attorneys Association. The counties continue to have control over the decision-making about whether or not a family can have reunification in partnership with the social services at the county level. If they don't agree to it, it simply does not occur, so there has a very high standard of proof that the family has to demonstrate in order to receive this very special right to consider reunification. If it's done under the right conditions, we think it's in the best interest of the child.
And let's talk a little bit about that. The Princeton Brookings Journal researched this issue. Now, it was back in 2004, but it came to this conclusion, quote, "Over the past 20 years, little progress has been made in defining and implementing meaningful reunification programs." Again, it's an older study. Do you think things have changed?
Well, I don't know how to respond to that because I'm not familiar with this study. What I do know, though, is that of the children that begin the year in foster care, very few of them, less like a third of them maybe, are successful in getting adopted, so they stay in a foster care system. So the question has to be asked, along with the questions raised by that study, is whether or not staying in a foster care system is in the best interest of the child. And if families have made significant improvement, why isn't it in their best interest if after the age of 15 they could reunify for those last 3 years before they become adult?
So this is a win-win, in your opinion?
Absolutely, it's a win-win. And I think we need to thank Ron Elwood and John Choi, Ron Elwood from the legal aid, representing legal aid, and John Choi, who is with the county attorneys in Ramsey County, for bringing forward this important legislation. It comes from the counties, and they're the ones that really have the control in the end over this. So I'm confident that we can review this and see that it's going well, and if there are problems. In the law itself, it allows, if a family falls back and starts to repeat their behavior, that they can lose their parental rights again. But I think the risk is minimal compared to what the positive outcomes might be for a young person.
Senator Kathy Sharon, thank you for coming in and joining us and talking about this legislation. Very important. We appreciate it.
Well, I thank you for the invitation.
The law that allows for same-sex marriage in Minnesota met with some resistance on the day that it took effect. This group traveled from Kansas to make their point on the issue. They were met by a larger crowd that supports the marriage law.
We did a total of 4 pickets, and we hit the locations where they do marriage licenses. And while we were in Rochester, we went to Mayo Clinic, and then we came here. And we went down the street here to where they issue licenses, and then we came up to the State House.
Were you surprised at all by the number of people here opposing your viewpoint?
It was kind of tame, actually. I mean, we're used to tens of thousands in some places. So this was tame, and the police did an appropriate job.
I am very happy. I watched my son, when they had the vote a couple weeks ago, my son sat and cried because he was so happy.
What are your personal feelings then, if you can expand on them a bit, of the message that was preached here today by the opposition?
They hate, and I don't believe that to be in a religious, that should be in a religious setting. I mean, you forgive. That's what God does.
Minnesota has a law called the Slayer Statute. It essentially prohibits somebody from profiting off of a death that they have caused. That law recently changed, and we sat down with Senator Bill Ingebretson to talk about those changes. So, Senator, let's begin with how does this new legislation, how does it revise what was currently in the statute?
What was in the statute it's been revised actually is it allows the victim's family, the alleged victim's family, to go to the court system and actually tie up the property until the prosecution of the criminal case is completed. That was not the case in Minnesota. So if a suspect were to have allegedly killed somebody, that suspect's heirs and family could actually sell the property, dissolve the property before the case was actually dissolved. And this puts a mechanism in place that allows the family members, whether it be a sibling or a child, to go to the court and ask for that property to be actually through a probate system in Minnesota, be able to be just stopped. In other words, it can't be dissolved until that case has actually been prosecuted.
So why did you feel the need to tighten this law?
Well, there was a case in Blue Earth County, I believe it was Blue Earth County, where the suspect's family actually dissolved and sold the property out from underneath the family of the victim. And unbeknownst to me, even being a law enforcement officer as many years as I had been, that there was such a thing that could even go on. This puts a mechanism in place. Now, this doesn't necessarily automatically happen, but it does give the family members of the victim the opportunity to tie up that property so it cannot be sold by the perpetrators, the alleged perpetrator's family.
How much say do the courts have on this statute, you know, on whether or not to tie up the property or whether or not to just let families dissolve it?
This would give them a lot. This would give them a lot of opportunity to do that, and it certainly makes sense if you think about it. If you're the victim's family and all the properties from the suspect was dissolved and sold out from underneath the other family members, it certainly would not be fair. Obviously it wouldn't be fair, but it just simply slows the process down and says, wait a minute, you can have money to get along, you can have money to exist on a daily basis, a monthly basis, but you can't just all of a sudden go out and dissolve all the property or get rid of all the property or sell all the property or change names of that property into other people's names until that criminal case is resolved.
And what if it isn't resolved? What if it remains open into perpetuity, as sometimes cases can be?
Yeah, you know, and I'm not sure of that. I guess that would be, again, the judge's option, but at least it gives the judge an opportunity to rule one way or the other, which was not in state law until this came into effect today.
And Senator, I've been reading a lot about the Slayer statutes throughout the country, and there are a lot of gray areas. There were a lot of different scenarios that popped up in various states. How do you think Minnesota's Slayer statute ranks? Do you think it's a pretty tight statute, or do you think there are a lot of other areas that could be addressed?
Obviously, it's a lot tighter than it was in the past, and as you know, before today, that anybody that actually went out and did some harm to somebody could actually turn around and sell that person's joint property without having the permission of the other people involved. So I think, I don't know how it ranks as far as statewide, but I think it's certainly a step in the right direction. If it needs to be looked at in the future, we certainly need to have it work for a little while to see how it does work. It doesn't happen every day, obviously. In Minnesota, we don't have that many homicides, but nevertheless, we could call it a work in progress like all statutes.
Okay, with those words, Senator Bill Ingebretson, thank you for joining us. We appreciate it.
Thank you so much.
Our discussion on laws that took effect on August 1st continues now with Senator Sean Nenow, and the senator joins me right now to talk a little bit about his legislation that changes intentional wildfire laws. So thanks for joining us. We appreciate this.
Glad to be here.
So Senator, let's begin with these changes. Apparently they stemmed from an incident in your district. Why don't you share the backstory?
Well, it was a fire in the Carlos Avery Preserve. The actual fire actually wasn't in the district I represent, but Carlos Avery comes up into the area that I represent in southern Chisago County. The fire was actually, I believe, in Washington and maybe Anoka counties. Destroyed thousands of acres of wilderness, but it endangered many homes and many acres of valuable cropland. Now, fortunately, in this case, there were no homes that were burned, there were no lives that were lost, none of the firefighters were terribly injured, but we had, I'm trying to remember the numbers, I want to say like a couple of hundred firefighters involved and dozens of trucks. They even called out the National Guard helicopters because this was an extensive fire. After the fact, eventually they determined that it was arson and they found out who committed the crime. Basically, the gentleman walked away with some probation.
And so your law is going to change that, and it's because there were no structures that had actually been burnt down. That's
right.
What this law addresses.
Right, because basically it was wilderness. It didn't really burn cropland, so it didn't create monetary loss. Because it didn't actually burn the homes, there wasn't that personal property loss and the monetary loss that would go with that. But you had this tremendous effort, which is the only reason that was prevented, was this tremendous effort. And the fine and the punishment that could be meted out on this individual because of the current law at the time was just minimal, even though you had 100 homes that were threatened and many, many acres of valuable cropland. The law was changed so that it doesn't have to burn down a house, an arson fire. Doesn't have to necessarily create that monetary loss. But if you have that threatened, if the arson fire, as a result of being set, then does threaten those buildings, and there's a tiered structure within the bill, so if it's so many of this and so many of that, it's this fine, and it can work its way up to a felony.
And I won't ask you to talk about all of those different tiers, but I did see that in this particular case, the damage would have likely resulted in a 9-year prison term. The bill allows for up to 10 years. Now, there wasn't much opposition to your legislation, but I did read that a few people did feel the punishment could exceed the crime at this point. What are your thoughts?
Well, you know, that could be the case with any crime. I mean, you look at some of these minor drug crimes in kids, because oftentimes it's kids, but, you know, guys and gals going to jail for 10, 15 years for using an illegal substance. There are people that say, well, you know, who are we? They weren't selling, you know, they just happened to possess it for their own use. Well, you know, that argument can be made for probably most of the laws that we have.
Okay, I want to ask you, just a hypothetical, but I'm trying to differentiate between what constitutes arson and what could just be an accident. Yeah. Let's say I'm just burning some dry branches in my backyard. The wind kicks up, carries it away. Next thing you know, you have a wildfire. Does that qualify as arson under this bill?
Arson comes down to intent. You know, did you intentionally set a fire that you wanted to burn out of control? In that particular case, you wouldn't have arson, you know, unless the arsonist was really smart and said, I know, I'm going to set a fire right next to this dry field because then I can claim that I was just roasting my hot dogs out in the middle of nowhere next to the dry field. But no, if you were having a backyard barbecue and there's a history of that, and what would happen in that case is you could maybe get into some negligence charges and, you know, restitution and things like that.
And that is my last question for you. In the case of many wildfires, typically, if there's some arson involved or even an intentional setting of a fire that wasn't negligent or that was just negligent, usually, you know, typically you have to pay for at least a big chunk of fighting that wildfire. Does your law allow for that as well? Yeah,
there are significant fines and penalties as well as prison time that could be meted out for that. And that was part of the problem in the case prior with what precipitated this legislation, is that it was just a nominal fine and, you know, time served in the holding cell is basically what it amounted to, and then some probation.
Okay. Senator Nenow, thank you so much for joining us. We appreciate it.
Well, thank you. You have a great day.
Work continues on Minnesota's Capitol building as contractors clean, repair, and replace some of the damaged exterior marble stones. Historical site manager Brian Pease explains architect Cass Gilbert's choice of stone and his use of French doors to create the regal look of the historic building.
Cass Gilbert, as the architect of the Minnesota Capitol, really wanted to have a building that would stand out among other buildings in downtown St. Paul. He didn't want a darker stone like a granite because he thought over time it would kind of be a heavier, glowering type of structure. And so the white marble was something that would really make this stand out for other people as they walked or drove by it and saw this beautiful state capitol. It was a controversial decision because it's a Georgia stone, a Georgia marble, and of course your granite producers in Minnesota or other stone producers are looking for locally produced stone to be put in your state capitol. They did compromise, so he was able to acquire the Georgia marble, and then on the ground floor of the capitol and the steps around the capitol, it was all made of Rockville or a St. Cloud granite. The French doors really are key elements to the architectural appearance of the state capitol. They're all designed with the intent of letting people out into balconies or egress areas outside of the building. So that's where you really get the grandeur of these large doors and all the light panes and so forth. Part of that too, you have to remember back when the building was open, it was wired with electricity, but electricity was pretty primitive at that time. And so the more lights, more skylights, the larger doors you would be able to put into your building would allow more natural light to flood into the spaces. And that was an important part of that feature for the architecture too.
Located on the second floor near the Senate chamber, the Senate Public Information Office is your first stop for help to navigate events at the Capitol. Let the friendly staff help answer your questions.
We're in essence a direct contact, first contact for the public. Who's my legislator? What district do I live in? What bills have been introduced? What committees are they in? Can I get a copy? Whatever questions they might have on the legislative process.
Good afternoon, Senate Information.
They can use our computer terminal and find out what committee meetings are taking place, check the status of a bill. If they don't know the bill number, they can do a subject search, an author search. They might come in to get our orders of business in terms of bill introductions, the agenda, the calendar for following a floor session. They might get the previous day's journal, get a copy of a bill, basically whatever they need to follow the day's goings-on. We're different in that we combine the public aspects of several different offices. Their chief clerk's office, room 211, bills and journals. Right next door, House Index. We basically handle most of the calls from the general public on the status of bills. And we also have some similar duties to House Information in terms of what district do I live in, who's my legislator, pamphlets, materials, that sort of thing. We have the Senate internship program, college students earning credit, working for the members. We have, I believe, 64 students this year, and we provide the selection process, the orientation program, and then various supplemental programs for the students. We're very accessible. Any questions they have, whether finding out who their legislator is, what bills that have been introduced, general process questions. If it's a question we can't directly answer, we'll promise to put them in contact with those who can.
That concludes this week's program. From all of us at Senate Media Services, I'm Julie Barkey. Thank you for watching.